And welcome to the Gay Liberation Network here on Chicago Access Network Television. I'm your host, Andy Thayer, and with me tonight is Richard Streetman. We're both, along with many other individuals and organizations, involved in organizing a big demonstration downtown Chicago on Monday night on the eve of the Supreme Court oral arguments about gay rights. Specifically, there were two lawsuits up. One dealt with California's Proposition 8, the anti-gay referendum that passed back in 2008, and the other was concerning the so-called Defense of Marriage Act, which is a federal bill that was passed by Congress and President Clinton back in 1996. And this has been all over the news. If you haven't heard about it, maybe you've been living under a rock. But Richard, could you explain to our viewers what each of these two measures meant to LGBT people? What did Proposition 8 say, for example?
Well, Proposition 8 back in 2008 passed, I believe, 52 to 48%. So it wasn't a huge margin, and everyone on each side of this issue would say today, if California voters were asked the same question, they would say they would legalize gay marriage in California. It had happened in the context of the California Supreme Court saying the California Constitution finds discrimination in marriage for same-sex couples to be unconstitutional. So the state court did that. And then California is a very liberal initiative process. Almost anyone with not necessarily having
money.
a large, money or just a lot of troops. I mean, the one thing about the religious right, there are a lot of conservatives, but the religious conservative form in this country is they meet every week, sometimes twice, at a place called church, and some synagogues and mosques and other places. And they also collect tithes, contributions, and they're able to do a lot of that, a lot of political work if they so choose with all of that. So, so
the Mormon Church was very involved,
Mormon was involved,
as was the National Conference of Catholic Bishops. Both played a big role in this, including our own Cardinal George gave a lot of money when he was president of the National Conference of Bishops.
So they amended the Constitution, circumventing the judgment of their Supreme Court in California. Now, some folks filed a case in, I think it's the Northern District of California, which is the San Francisco area. A lot of national groups like HRC, I'm not even sure how Lambda felt, but a lot of national groups didn't support that filing back in 2008. Yeah. Now all those groups are lined up out in front of the Supreme Court talking about all their great work, and it turns out the country moved. The country moved. I think legal precedent moved. I think the justices, everything has changed. I was nervous when people started talking about filing these cases.
But that people aren't going to sit back and wait. I mean, that if the African American Civil Rights Movement taught us anything, and we've seen this over and over again. Lawrence v. Texas, the decision that struck down all the anti-sodomy laws that finally laid the basis, I would argue, for the successful moves for equal marriage rights and successful courtship. challenges. That was also that lawsuit, Lawrence v. Texas, was also opposed by Lambda Legal and all the other national organizations, and Lambda only got on board after a full head of steam worked up. So we've seen this script before. Now, the Defense of Marriage Act. Tell our viewers what was meant by that, and what does it mean to same-sex couples in states where marriage is legalized?
Well, I think the Defense of Marriage Act was a completely political act. The president in 96 was, of course, Bill Clinton. He was facing re-election. He came in office in 1992 having thought it was a harmless promise to say, we'll end gays in the military. And he found that to be his first controversy after becoming president. And I think once the president dealt with that and then lost the majority in the House and Senate of Democrats in 1994, he did what they call triangulation. He brought in, I think it was...
he threw us under the bus.
Dick Morris. Well, he threw everyone under the bus. He did well. I mean, I shouldn't say
himself.
He threw what was traditional Democratic constituencies under the bus to get reelected in 96. And looking back, some of us say maybe he didn't even have to. I mean, he was running against Bob Dole. But you know, who knows what part almost 20 years ago was that made him conservative enough to get reelected. Mm-hmm. But he did not sign it, you know, proudly. He signed it in the middle of the night.
Well,
but
he actually went on radios. He took out paid ads on Christian right radio stations to brag about signing it. So
right.
he was happy to trumpet that signage to
those
at least
people.
some people.
Yeah.
Yes. Anyway, rolling forward to this week, we've had a situation on Tuesday where there was one of the lawsuits against Proposition 8 was heard in oral arguments, and we also had then on Wednesday the so-called oral arguments about the Defense of Marriage Act, and both of these cases were, I think, frankly, especially on the first day, our side was trimming its sails way too much, to put it mildly. There's this real attempt to say, oh, let's not go to the full implications of what equal rights under the law means. Let's try and just, in terms of Proposition 8, let's only have this apply to the states that have got civil unions. The Solicitor General representing the Obama administration really pushed that,
right.
Which I think all I could think when I was hearing this is, where is our Thurgood Marshall making the bald case for equal rights under the law? And it certainly wasn't happening there.
I have a different take on that, in that, you know, the big landmark case that Thurgood Marshall argued that one talks about today, and that I alluded to on Monday when I talked about the Plessy case, is not separate's not equal, is the 1954 decision, Brown versus Board of Education, that Thurgood Marshall argued for the NAACP Legal Defense Fund. He had argued cases for a decade prior to that. Mm-hmm. There were very small decisions. There were things about interstate busing, and the Supreme Court then did not immediately go from being a Plessy court that allowed discrimination wholesale to saying separate is unequal. And even when they did the 54 decision, they said desegregation should happen in, quote, all deliberate speed. My schools in South Carolina did not integrate until 1970.
Well, I think the big difference there was between today and 1954 was that was way before the African American civil rights movement had really gained a full head of steam, not just in terms of mobilizing people in the streets, which we have consistently out-mobilized the anti-equality forces this past few months, but also public opinion was unfortunately very much against African Americans in terms of the overall majority of white Americans opposing equality, whereas today, poll after poll over the last year or so has shown solid pluralities for supporting equal marriage rights. So my opinion is that you strike while the iron is hot, because while we may have the polls in our favor right now, 5, 10 years, or 20 years, which may be the next time we have the opportunity to have a case before the Supreme Court, we may be in a situation where we're in deep economic crisis, and the politics of the country have gotten much more nasty as a result. You have to look no further than much of Europe right now, with the rise of the fascist right, with regular political attacks, not just on LGBT people, but immigrants and others who are seen as the others. So I think to not push for full equality now is a serious strategic error. I, for one, was really upset when Donald Verrilli, representing the Obama administration, really tried to just trim the sails on that. We're going to have opportunity for your calls in a couple seconds here, but first I'd like to call attention to a few announcements how you can get involved in the movement. First of all, if you're interested in getting involved in the Gay Liberation Network, please check out our website, gayliberation.net. You can get all sorts of information there. Also, if you want to get involved in GLN, our next meeting is always the first Wednesday of the month, this time April 3rd at the Burger Clark Cultural Center, corner of Sheridan Granville. And Bradley Manning, the gay WikiLeaker. There's going to be an International Day of Action on Saturday, June 1st. We'll be having one here in Chicago, location and time to be announced, but that is just 2 days before Bradley Manning's trial. And so people around the world will be rallying in his defense Saturday, June 1st. And also something we talked about at the rally the other day, the decision day for the Supreme Court. What is that website, Richard?
Decisionday.info, which then points to a Facebook page, but of course no one can ever remember all those numbers.
Decisionday.info.
Decisionday.info.
We've got, unfortunately, a different website up here on another screen here. We won't bother you with it. But again, check that out. If you want to get involved in the conversation, just call that number on your screen, 312-738-1060. Now, what was your impression of day two, the discussion of the Defense of Marriage Act? They spent a lot of time talking about standing.
Yeah.
Explain that to our
when the founders established the United States Constitution in 1887, was it?
No,
yeah,
1787.
Sorry, 100 years there.
Lost a century there.
1787. They gave the United States Supreme Court jurisdiction over only actual cases and controversies, which means that two entities, two sides have to be in a case, a pro and an against, or whatever, the two sides. In this case, where traditionally the Solicitor General of the United States, Mr. Verrilli, would defend Congress's laws when they're passed by Congress and signed by the president. They have to defend them. It doesn't matter who's president. That's the rule. Our Attorney General and our President have determined that the Defense of Marriage Act, and they actually agree similarly with Proposition 8, are both unconstitutional. And they've said they wouldn't defend the cases, but they then appealed the case in order to bring it to this level. Now, in both cases, there's standing issues because both in California, the governor there and the attorney general there, similarly charged with defending the laws of their state, have said, they're all Democrats. We don't agree with this discrimination. We're not going to defend it. So in California, the right has hired counsel. In the DOMA case, which is a federal law, the House Republicans have brought in counsel. And what the justices have to determine, and they've hired their own attorney to look into it and see if standing is there. Standing is
whether or not you can appear before the court.
Whether there is another side. Because if you have the government agreeing with the person who's suing the government, where's the controversy? Where's the case? And that sounds like a great thing because everyone agrees, but what happens is the Supreme Court doesn't decide. They can say there's no standing and just kick it back, which means in this case Edith Windsor gets her money, but there's no legal precedent. It means nothing to anyone else.
Yeah, and I think it was very dangerous, especially in the Proposition 8 case. I think it was very wrong strategically on a number of levels for the people arguing for the pro-gay side to say that the people representing the pro-Prop 8 side, quote-unquote, had no standing. For one thing, the people who were on the other side were the people, almost all of them, all of the people who had worked to put the Proposition 8 measure on the ballot. And as much as we might loathe that and find it completely offensive, unfortunately, this sets a horrible precedent, if it's successful, in saying that the governor, or whomever he decides to lean on in terms of the state's attorney general, whomever, can simply say, oh, I just don't like what referendum passed, because the whole purpose of having ballot initiatives is to hold elected officials in check. And I think it sets a very dangerous precedent if the people arguing the pro-gay side are successful in that. So as a gay person,
it can go both ways. If we pass a civil rights law or something progressive, and they decide not to, the next Ronald Reagan governor of California doesn't want to enforce it.
Can nix it.
Right.
And also I think it goes to another problem, which is that I think in order to win pro-civil rights gains, the last thing you want to do is appear to be pulling an underhanded lawyer's trick, if you will.
Right.
And this is precisely how Anita Bryant in Dade County, Florida, way back in the day, got her start, when the pro-gay side snuck through some legislation that said that there was going to be equal employment. They purposely kept it totally under wraps, and the anti-gay side was able to play the populist card and say, oh, look at these sneaky gay people trying to sneak legislation in. And Anita Bryant rode a backlash. And so I think, especially in a situation where we clearly have got public opinion on our side, it's really a wrong move. Let's have a clear decision. And let's not have the sort of halfway house that the Obama administration Solicitor General is
that kind of
for.
Brings up, actually, one of the possibilities I think that a lot of court watchers are thinking might occur in this case. A lot of folks are suggesting that in the Prop 8 case, there's a good chance that the court doesn't want to move too fast. We saw last year with the Obamacare case that the Chief Justice doesn't want the court to look like
radical,
right? Or he knows in 10 years that this will have happened. Everyone knows, maybe 5 or 10 years, through whatever mechanism. And therefore, do you want to be a court that's seen as bigoted for all history
and
lose the respect of the people more than you already have in with Bush v. Gore and other things? So he was surprised.
United.
It wasn't Justice Kennedy last year that saved Obamacare. In fact, he voted with the conservative minority. It was Roberts. And I think that a lot of people, if you listen to them, in the Prop 8 case, I think there's a good chance they're going to go with standing, because they know if we just say we can't hear this because there's no standing, then it goes back to California, where both the appellate court, and they can kick it back probably to the district court and vacate the appellate, which would then mean in the state of California of gay marriage. It doesn't really set the precedent. It won't be there's going to be gay marriage in Arkansas and in Alabama and South Carolina, where I came from. But they know if they did that overnight, this is particularly important to one of the liberal justices, which you have to have them solid. Ruth Bader Ginsburg has said forever, Roe v. Wade was a mistake in that what it created was a political problem. By the court making abortion nationwide legal, they circumvented, in her opinion, the political process, which we're in the middle of, making gay marriage legal state by state by a democratic process.
But I think that's a real misreading of history. I mean,
but that's their misreading, and they're the ones voting.
That's their misreading. But I think, unfortunately, some people who are not on the court, who are on the pro-gay side, have accepted that logic, which I think is very wrong. And we can get into that in just a minute. We do have a caller, so let's invite that caller on the air.
Yes, I want to make the point that I think that there exists, in terms of the structure of the Supreme Court today, a huge disconnect between that and public opinion. And this is going to be an issue going forward decades, because we've got a court that's much further right than the country is on a great many issues. And given that many of the justices that define the right on the court are so young, that they are literally going to be decades behind where the nation might want to be in the decades to come. So this is going to be a problem. It's going to continue to be a problem. So I don't know that there is a way to address this, again, unless you want to pray for, someone to die, which I don't think any of us want to resort to. But really, that's the only way that people usually leave the court. Some do retire, but by and large, again, the constituency on the court that is conservative is young, and they seem to be running contrary to, shall we say, that great historical arc of justice. Thank you.
Well, thank you, caller. One thing I would point out, though, is that it was a Nixon-packed Supreme Court that gave us Roe v. Wade in the first place, and he specifically tried to pack it with conservative justices. But there was a massive women's movement in the streets, and the illogic of the argument concerning that apparently Ruth Bader Ginsburg holds, she had a big profile in the New Yorker magazine a few weeks ago, was that it ignores the very different times. And when Roe v. Wade was finally handed down was after the women's movement had peaked.
And I believe the Republican Party supported it then too, in the early '70s in their platform. It was a different party.
It was a different party, but also that I think that there is a real opportunity here to push for equal marriage rights. That if we don't get it through the courts, it ain't going to happen in South Carolina anytime soon. And a lot of same-sex couples are going to be hurt in the process. And I think the elderly lady who was represented Edith Windsor is a case in point where she paid a huge tax. She's not going to be around 3 decades from now. She's an old lady, and she's going to be screwed if this does not go in our favor. So we do have another caller. We're going to have to be brief on this because we're getting close to the end of the show. Yes, caller, you're on CAN TV. What's your question or comment, please?
Hey, guys. I just wanted to ask real quickly, the Supreme Court decision, if it does not go in your favor, is this going back to California, and is this movement going to start all over again? Is this just a fight that's going to continue if the Supreme Court does not rule in your favor?
I think regardless of which way the Supreme Court rules, it's not over. For one thing, enough of our community is mobilized, enough people have been educated to the basic tenet that discrimination against a whole group of people is bigotry, and discrimination is based, one central feature of it is legal inequality for a whole group of people. So there's no way we're going back. And the decision day demonstrations that we just had on our screen a little bit earlier, and we'll pop that up and again, that's specifically aimed at saying whichever way the court rules, we are going for it. If it's full square against us, we're not going to take it lying down. We're going to be in the streets. We're going to demand our legal equality. If we get a middling decision, which seems to be the most probable, a rotten compromise, one that does not recognize equal protection under the law, then we are going to be saying, this is not enough. We won't accept it. If we get a total victory, it's only a legal victory. And we realize that, as with African Americans back with the great civil rights legislation in the mid-1960s, legal equality is not all it's cracked up to be. You need social equality. You need real implementation of that legal equality. So whichever way, we are going to be in the streets at 5:30 p.m. in this town the night that the Supreme Court announces its decisions, probably going to be late June, right around Gay Pride Day, as it turns out. So that's what's going to be on the agenda. Unfortunately, we're going to have to be wrapping it up here. This has been Andy Thayer with the Gay Liberation Network, Richard Streetman, one of my fellow organizers of the big demonstration the other day, and demonstrations, 170 plus cities around the country, all 50 states, arguing, demanding that the Supreme Court recognize equality for lesbian, gay, bisexual, and transgender people. So with that said, thank you for watching tonight. Here are a few announcements. Again, the Bradley Manning Day of Action, Saturday, June 1st, location to be announced just 2 days before his trial. And then we've got the Supreme Court Decision Day demonstration coming up 5:30 p.m., the day that the Supreme Court announces its decision. And then, of course, we have got our next GLN meeting. This is how you can get involved in the Gay Liberation Network. We meet the first Wednesday of each month at the Burger Park Cultural Center. And then, of course, our next GLN show is going to be the second Friday in April, which is Friday, April 12th. And please check that out here on CAN TV, cable channel 21. And then finally, we want to thank those who made tonight's show possible.